Hey everyone, welcome back to Girl Talk. Thank you so much for joining me. As always, before we get started, if you could give me a like, share, a thumbs up, comment, subscribe, and notifications, I would appreciate it. So, today we're going to do the bankruptcy uh, dismissal for Ronn and Jan Owens. And if you're following this, they are Laura Owens' parents, and she is the one that supposedly got pregnant from The Bachelor, Clayton Eckert. She did not. And we went down that rabbit hole, and it is just insane. So it's only about 20 minutes long, and we're going to listen through Schnitzel Ninja, and I will tag her in the comments. So here we go. Let's take a listen.
In the case 2605144, Elizabeth Naylor and Ronald Owens.
Good afternoon. I'll take the appearances in the Owens and Naylor matter. Let's start first in the courtroom.
Thank you. Good afternoon, Your Honor. Jennifer G. I'm on behalf of the U.S. trustee.
Thank you. Good afternoon. And I'll take appearances from Mr. Owens and Ms. Naylor.
Yes, good afternoon, Your Honor. I am Elizabeth Ann Naylor, appearing pro se.
And I am Ronald Stephen Owens, also participating pro se.
Okay, thank you. Good afternoon.
Sure.
All right, let's go ahead and get started. We've got two matters on calendar. This time set for continued Chapter 11 status conference, as well as a hearing on the debtor's motion to dismiss this voluntary Chapter 11 case. I'm aware of the parties' filings, but let me turn it over to you to see how we wish to proceed. Shall I start with you, Ms. Jamo?
Thank you, Your Honor. Yes, so just to remind Your Honor, the debtors had filed a motion to dismiss, and at the last hearing at which that was raised, Your Honor wisely pointed out that we needed to collect some documents and do more investigating before the case should be dismissed. I'm very glad that Your Honor had required that. We did receive what was called an accounting of the GoFundMe funds, and we received many bank statements that I was able to review. As the U.S. trustee laid out in her recent supplemental response to the motion to dismiss, there was some disturbing material that came out through our investigation. And for that reason, the U.S. trustee's position is that there's definitely bad faith here and the case should be either converted or dismissed. And also, as laid out in our supplemental response, we think that based on our analysis of the assets, that dismissal with a 2-year bar to refiling would be the wiser choice, because there does not appear to be really any sure collectible assets in this case.
Right. Thank you. I did have an opportunity to review your supplemental response at docket number 89. Tell me more about why the recommendation is for a 2-year bar to refiling. Often we use a shorter period if there's a secured creditor looking to foreclose, or a longer period if we're looking for litigation to conclude. 2 years is pretty lengthy, so could you give me some additional information about that long period? And also, it's my understanding that Ms. Naylor and Mr. Owens have agreed to that period. Is that correct?
Yes, Your Honor. Yes, I should have pointed that out. Yes, Ms. Naylor and Mr. Owens, in correspondence with me, have indicated that they were willing to have the case dismissed with a 2-year bar to refiling. So the reason that we're asking for 2 years is because this case was filed in bad faith, we need to have a sufficient deterrent to prevent another repeat filing that would, again, interrupt creditors from pursuing their rights. 2 years, just weighing it, seems like an adequate amount of time to allow a foreclosure of the home to follow through if that's what's going to happen. I understand that there was a foreclosure set first in May, then I think it was reset to September. Now I believe it's reset to November. Ms. Naylor would know that information better. I don't know what is going on with that process, but it seems to me that that is the driving force behind these bankruptcies is the house, right? So I think that we absolutely need to give the creditor sufficient time to foreclose on the house if that's what's going to happen. I think 1 year might not necessarily do it, especially if they're trying to work something out. And so I feel like it's actually to the benefit of the debtors to have it be 2 years.
Wait, did you just say it would be to the benefit of the debtors to be 2 years?
Well, yeah, because maybe that gives because if there's that much leeway given to the mortgagee to foreclose on the property, maybe they'll be a little bit more willing to spend some time trying to work something out with them.
Oh, I see. So should the mortgage company have additional time during which Ms. Naylor and Mr. Owens cannot file bankruptcy, they may be willing to enter into negotiations during that elongated period.
Right, exactly.
I understand. Thank you.
So there's that, and also there were 2 lawsuits against the debtors that those can proceed. And I think that based on the information that we discovered and laid out in our supplemental response, there are potential claims, I believe, by GoFundMe Inc. or donors. We definitely need to make sure that there's sufficient amount of time to allow those parties to pursue any rights if they choose. I mean, I have no involvement in that, but just based on my own investigation. So I think 2 years gives an adequate amount of time and is proportionate to the bad faith that we've seen here. And it gives an adequate amount of time to allow creditors to pursue their rights in state court, which is really what we want, right? That's the best interest of the creditors. And yet it doesn't completely foreclose the debtors from refiling should the need arise later, but there's a sufficient buffer with a 2-year bar so that creditors won't be harmed yet again.
Okay. Thank you for explaining that. One reason I had asked is just because there was the pending foreclosure sale. The court previously declined to extend the stay.
Yes.
And so it seemed that the mortgage company could move forward. Plus, under Arizona statutes, they could foreclose within 90 days anyway. So it just seemed like a long period. I hadn't really considered the idea that a longer period would actually motivate the mortgage company to engage in negotiations. Have you seen that happen before?
No, but I don't know why the mortgagee is continuing to move out the foreclosure date, so I'm assuming that they're working with them. That's all. I really don't know. I mean, I've tried to reach out to them, and they've not really been very responsive to me, to the banks. So, that's just one factor, but I do believe that we should have sufficient time to allow creditors, not just the creditors that were listed in the schedule, but other potential claimants that I mentioned in our supplemental response to pursue claims against these debtors without a bad faith bankruptcy filing.
Okay. Another area of inquiry, and you did address it in your supplemental response, was just whether conversion would yield any distribution. I read what you wrote, and I certainly appreciate that trustees are loath to have cases where we have animals that need care and food, etc. It ends up costing them money as opposed to yielding benefits for creditors. So I certainly understand the reasoning of the U.S. trustee there. Is there anything else you want to tell me, not necessarily specifically with animals, but any of the other assets in the the opportunities for recovery?
Well, Your Honor, I should mention to you that while the case was in a Chapter 13, there was a short time during which these debtors' case overlapped with the filing of a Chapter 7 case by the debtor's daughter, Laura Owens, and the attorney representing the Chapter 7 trustee in the Laura Owens case was Terry Dake. And I know that he was very actively looking into potential assets, and if you recall, there are some businesses that are co-owned by the daughter and either Miss Naylor alone or Miss Naylor and Mr. Owens with the daughter. And I did reach out to him to ask him what his professional opinion was as to whether the preferences made to the daughters is something that he looked into and whether there was any assets that he could conceive of either in the Chapter 13 case or in the Chapter 7. And it was his opinion just to me, in an informal discussion about it, that this did not seem like a good case for conversion. So we did factor that in. I didn't put it in the pleadings because it wasn't a real formal discussion. It was just something that I had run by him because of his familiarity with the case. But I did agree with his assessment based on my own analysis of all of the assets that are disclosed.
Okay, thank you for that additional information. And I do recall a prior hearing you had mentioned Mr. Dake was involved in this case in some respect. So now I understand it's with the debtor's daughter. Yes. Okay. Yes. All right. What else do you want to tell me?
Your Honor, I think we just pretty much laid it out there. We think that there's definitely concerns, but in light of the financial situation, conversion would not make sense. It would be really a burden, I think, to any Chapter 7 trustee to ask them to take on such a case. So I do think that dismissal with a 2-year bar is the only way to handle it because of the bad faith. I do think there was a lot of bad faith, and that because of that, that's why we should have a little bit of a longer bar on refiling, because this is one of the worst I've seen in terms of misstatements, misrepresentations, and I would ask that that's what Your Honor do, especially in light of the fact that the debtors are agreeable to the 2-year bar.
All right. Thank you, Ms. Jamo.
Thank you.
All right. I know that there are a number of individuals who are appearing by Zoom. I'm wondering if there's anyone present who wishes to be heard before I return to Ms. Naylor and Mr. Owens. All right, hearing no one speak, I'm going to go ahead and turn to you, Ms. Naylor and Mr. Owens. What do you want to advise the court at this time?
That we have reviewed the trustee's supplemental response. We agree with the final recommendation to dismiss the case with a 2-year bar, but we would like to state respectfully for the record that we dispute any insinuation of any sort of fraudulent intent or bad faith. As pro se debtors, the Chapter 11 reporting rules were very complex for us, and any omissions or anything like that were honest, unintentional mistakes that were due to our lack of counsel, and we feel we cooperated fully and provided any of the bank statements for 18 months, anything that we could to ensure total transparency.
Okay, so tell me about the 2-year bar date refiling. What is your position with respect? It was represented in the record that there was a stipulation and agreement to that period.
We had informal discussions with regard to that, and we had told the trustee that we were willing to go with a 2-year bar. I mean, frankly, we hope we are never, ever, ever in this situation again. And as we had explained before, we are trying to explore what options would be available for us to modify the mortgage and to come to agreements with the other creditors to resolve this outside of bankruptcy.
Okay. Are you engaging with your mortgage company or others in terms of in an effort to resolve those outstanding claims?
Yes, and we had, as far as the mortgage is concerned, we very much appreciated your suggestion that we work through I believe it's the MMM program through the bankruptcy court. And when we explored that, it appears that would only come into play while we were actively in bankruptcy, and that once the case would be dismissed, that entire process would go away. So we have been trying to work through correspondence with the mortgage company, and we have again been told that in response to our latest communication with them, our latest letter with them, with the latest correspondence, that they will respond to us within 30 days. So perhaps that's why they maybe have moved out the foreclosure date more. But we are certainly wanting to work behind, the scenes outside of bankruptcy court with them to resolve this.
Okay. Well, very good. I wish you good luck in that regard.
Thank you, and thank you again for your recommendation on going through the mediation program in the court. We really wanted to work with that, but it just looks like that ends when the bankruptcy would be dismissed.
All right, what else do you want to tell me?
Just that I think regarding the GoFundMe campaign, we wanted to stress that there were no promises that were ever made to the donors, and that this was an effort that was the culmination of my husband's decades on the air, and he and our family were very, very deeply touched by the outpouring of support from his listeners, who have truly become like an extended family to us over the last decade. So this was an appeal that was needed for housing and food and transportation and those kinds of things, and we were just very, very grateful for those contributions.
All right, thank you. Anything further?
Not from me.
Okay. Mr. Owens, did you say something, sir?
Yeah, I said none off the top of my head.
Okay, all right, thank you. Let me turn back to Ms. Jamo. Anything further, ma'am?
No, Your Honor, I don't think it's necessary for the U.S. trustee to get into a back and forth with the Owens about the GoFundMe funds. Our pleadings speak for themselves, and it's not an issue that is going to be resolved here in any event, so we'll just leave it at that.
Okay. Let me ask you this. With respect to a dismissal, is the court's signed minute entry sufficient, or will your office wish to upload a formal order?
I think the court's minute entry would be fine. I don't want to have to deal with having to go back and forth and try to make sure that we're on the same page. I mean, especially because we have Ms. Naylor and Mr. Owens here on the record. You're seeing them here, I'm seeing them here, and it's clear that they're voluntarily agreeing to this. I would be comfortable with a minute entry of dismissal saying that there's it's a 2-year bar of refiling. Although I guess I wonder if we do need an order on the record so that if another case is filed, there's something more clear on the record.
The clerk's office should be able to pick up from the minute entry what we call an exception, and so it would be noted so that if another case is filed, it would trigger personal or direct review. Let me check with Ms. Hall and make sure I'm not mistaken in my understanding, but I think that's accurate.
Judge, it would be in the ordering paragraph as well.
Okay. Right. So the minute entry will suffice for a bar date.
Perfect.
Okay.
That works.
So nothing else. And so Ms. Naylor and Mr. Owens, just so you're clear, I was just asking Ms. Jamo about the form of order that the court will issue. Generally, we issue minute entry after every hearing, and I'm happy to sign that minute entry, and that will be the formal order of dismissal. And I was asking whether Ms. Jamo's office would prefer to have a specific form of order of dismissal. She's concluded, and I agree that that's not necessary. I'm just giving you the courtesy of asking whether for some reason you would like that.
No.
Okay. All right, then. I'm prepared to make a ruling. Thank you, everyone. All right. So the matter before the court today is the debtor's motion to dismiss their voluntary Chapter 11 case. The debtors filed this motion, and afterward, the debtors and the United States Trustee's Office have come to an agreement for dismissal of this case with prejudice, and they have agreed to dismiss with prejudice with a bar to refiling this case or any bankruptcy case for a period of 2 years. I've reviewed the motion. I've considered the parties' stipulation, the record in this case, and whatever arguments have been made by the parties. The court does find and conclude that cause exists under the United States Bankruptcy Code, Section 1112B, to dismiss this case. The record does demonstrate that the debtors have been unable to satisfy the obligations imposed under Chapter 11 and upon Chapter 11 debtors, and it's also clear that there is no reasonable likelihood that this case can proceed to a successful reorganization within a reasonable period of time. The court further finds that dismissal, rather than conversion, is in the best interest of the creditors and the estate. I've considered the scope and the nature of assets and the potential for transfers that could be avoided or other claims, and it appears that that would be very difficult and costly for any Chapter 7 trustee to undertake. The remaining question is the scope of any prejudice to refiling. Although the parties have stipulated to a 2-year refiling bar, I believe it's incumbent upon the court to independently determine whether that requested relief is warranted under the Bankruptcy Code and the facts of the case. In particular, since we haven't had an evidentiary hearing. A dismissal with prejudice and a prohibition on refiling constitute extraordinary relief. And generally, the court's rule is that such a bar should extend no further than necessary address the conduct that has been presented to the court. So again, I do find that cause exists to impose a refiling bar. The record reflects significant failures to comply with the requirements of Chapter 11 and demonstrates that dismissal without prejudice would not adequately protect the integrity of the bankruptcy process. Accordingly, a period during which debtors may not seek relief in bankruptcy is appropriate. The court is also persuaded by the multiple errors, the misstatements, and even possible misrepresentations that the present record does justify a 2-year prohibition on refiling. The court concludes that a 2-year bar will accomplish the purposes of 11 U.S.C. Section 105A and 349A. A 2-year refiling bar adequately protects the bankruptcy process, discourages abusive or premature refilings, and is appropriately tailored to the circumstances of this case. In particular, because the debtors have consented to that 2-year bar, and Ms. Giamo points out an unusual and perhaps novel consideration the court had not previously considered, which is that with more time provided to the mortgage company, perhaps the parties can enter into an agreement or arrangement that meets all the parties' needs with respect to the real property. So for these reasons, the debtor's motion to dismiss is granted. This Chapter 11 case is dismissed under 11 U.S.C. Section 1112B. The dismissal is with prejudice to the filing of any bankruptcy petition by either debtor under any chapter of the Bankruptcy Code for a period of 2 years from the date of the entry of the dismissal order, which shall be the minute entry that will emanate from this hearing. I'm not expecting any additional form of order. Rather, as soon as this minute entry is filed, the case will be dismissed, and that will be the end of the matter. And with that, I believe everything that we were here for today has been considered and concluded. Is there anything else we need to discuss, Mr. Owens and Ms. Naylor?
Nothing.
No, just thank you very much for allowing us to appear via Zoom with the heat today. It's a lot more comfortable for my husband and for me. So thank you.
Great. Well, you're welcome and good luck. Ms. Giamo, anything further, ma'am?
Nothing further from the U.S. trustee. Thank you very much, Your Honor.
All right. With that, then we are adjourned. Thank you, everyone. Good luck.
Thank you.
Thank you.